Ohio has a well-established framework for habitability that balances landlord and tenant responsibilities fairly clearly. If you manage rental property in Ohio, your roadmap is the Ohio Landlord-Tenant Act, found in Ohio Revised Code, Chapter 5321. Under Ohio law, landlords have a specific set of obligations spelled out in Section 5321.04. You must comply with all applicable building, housing, health, and safety codes. You're required to make all repairs necessary to keep the property in a fit and habitable condition, keep all common areas safe and sanitary, maintain electrical, plumbing, sanitary, heating, ventilation, and air conditioning systems in good working order, provide running water and reasonable amounts of hot water, provide trash receptacles, and arrange for removal if the landlord is responsible for that under the lease or by local ordinance, and supply working smoke detectors. What's notable about Ohio is how the statute addresses the relationship between landlord and tenant obligations. Ohio law is very clear that the tenant also has statutory duties: keeping the property clean, disposing of trash properly, using fixtures correctly, not disturbing neighbors, and complying with health and safety codes. If the tenant's own actions caused the habitability issue, the landlord's obligation to repair can be affected. Ohio courts look at both sides of the equation when a dispute arises. Ohio's remedy process is structured. If a landlord fails to fulfill their obligations, the tenant must provide written notice specifying the problem and giving the landlord a reasonable time to make the repair. Generally 30 days for non-emergency issues. If the landlord doesn't act within that window, the tenant can pursue remedies. Here's where Ohio gets specific. Tenants can deposit rent with the clerk of courts rather than paying the landlord. This is Ohio's rent escrow remedy, and it's governed by Section 5321.07. The process requires the tenant to be current on rent, to have given proper notice, and to deposit the full amount with the court. The court then decides whether to release the funds to the landlord or hold them until repairs are completed. Ohio tenants can also seek a court order requiring the landlord to make repairs, recover damages, and, in some cases, obtain reasonable attorney's fees. If conditions are severe enough, tenants can argue constructive eviction and terminate the lease. One area that Ohio takes seriously is lead paint. Properties built before 1978 are subject to federal disclosure requirements, but some Ohio municipalities have additional local lead paint regulations, especially Cleveland and Columbus. Landlords in those cities should be aware of extra inspection and certification requirements. Ohio's anti-retaliation provisions protect tenants who exercise their legal rights. Landlords cannot raise rent, decrease services, or file for eviction in retaliation for a tenant making a habitability complaint or using the rent escrow process. For a complete breakdown of Ohio's habitability requirements, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel to stay informed on landlord-tenant laws in every state.